ஆஃப் பண்ணுங்க. தூங்க வைங்க. ம்.
Good evening, all. Welcome to the session organized by Middle East Quantity Surveying Association. Before we start, I just want to confirm whether can you all hear me loud and clear? Can you please type yes or no, please?
Yeah, we can hear us.
Good. Okay. Thank you. Thank you. Okay. Okay. And one more thing that I want to tell, please switch off your camera as well as mic. So there will be a time at the end of the presentation, you will be provided enough time to ask your questions related to the presentation. So please keep your mic mute. So that will help all others to learn as well as hear clearly. To make sure that your surrounding will be, correct. Okay. Okay, someone say that my voice is not clear. I think it's maybe your internet connections. Make sure that you have a good internet connections, as many of them confirm they can hear clearly. Okay. I just want to ask, Joseph Kikuo, is it possible for you to switch off your camera, please? I think he's not in front of the camera. Okay. All right. Without further delay, I think we can start this session. As we are going to learn a lot of things. I don't think the 1.5 hour allocated by MEQSA it's going to be enough for us to complete all the slides in relation to the extension of time. But let me start without a delaying time so everyone can join while we start our session. All right. Today, especially as they have circulated the flyer, we are going to learn about extension of time under FIDIC 1999. As we all are working in the industry of constructions, of course, most of the time we do feel that, or we do face a problem of handling extension of time. As a QS or commercial manager or contract manager, we do think that extension of time should be evaluated or analyzed or maybe identified or evaluated by a person who is expert in it. But guys, can you please switch off your mic kindly? Thank you. Okay, so I think MEQSA organizes in process here. If possible, please send message in chat room so people can understand and switch off their camera as well as mic. Okay. So to continue that, what I want to say that everything is from experience as well as learning. You should not fear or you should not, go back when you receive some sort of extension of time claim. Because extension of time claim, it is one of the interesting session or chapter that you are going to interfere or you're going to enter or deal when you're working as a construction professional. I have worked with one of the major claim while I was working for one of the biggest constructions of the region, airport construction infrastructure. While I was working for that, I got a chance to involve in one of the biggest claim in relation to EAT, extension of time. For the day of 196 days we have applied, and successfully we have secured 180 some days. So what I can say as an advice to you all, when you face or when you receive a claim from the contractor or maybe anyone else, make sure that you will approach that with confidence as well as with enough knowledge. So what we are going to learn here, as we all aware that FIDIC is one of the well-known standard form of contract being used in GCC as well as many other countries. So if we can familiarize with the thing that portrayed or delivered by a FIDIC, of course, with the confidence, we can go to handle all other extension of time. Before we go very deep into the extension of time under FIDIC 1999, I just want to give you some sort of information that what are the things that we are going to learn. So in terms of the thing that we are going to learn today, I would say that we are going to learn mainly a couple of things, such as what is extension of time and what FIDIC say, or what is the stand of FIDIC in terms of EOT, extension of time. And what are the grounds for a contractor to entitle or to claim any extension of time in terms of FIDIC 1999? And what are the associated entitlement to payment of costs? What are the clauses says and what kind of costs that they can claim? And the next one that we are going to see, a procedure as well as entitlement. And the final thing that we are going to see, what is the period of extension time and how or what we need to consider when we offer extension of time to the contractor. So, of course, we are with different backgrounds. Of course, some of you come from contractor, some of you from consultant, some of you from consultant in terms of PMC, as well as some of you from maybe from client. So we all, of course, we need to work in a collaborations method or manner to handle as well as successfully and in a fair manner to identify the extension of time and successfully, amicably settle that problem. So when we have enough knowledge as well as understanding of the thing, of course, that will be very easy for us to handle with the confidence and solve the problem without any hesitation. So as these are the things that we are going to learn, next thing is what we're going to see, that we are going to see about many information. Very first thing that we are going to learn about extension of time. Of course, within the projects or maybe for a client or a contractor, of course, in real life, project needs to be done or completed within a certain time. Of course, they want it to be completed within a certain time. Most of the time, design will reflect the time required for that, for the client requirement. For example, if clients wants to construct a complex or shopping complex, of course, he will tell his requirement as a brief to the party who's going to design it that I need to complete this construction within so-and-so days, so-and-so years, and I need to start my business on so-and-so days. So when client gives his requirement to the architect or the designer will design his development of the design to complete that project within that certain period too. So they can't make it very complex, which is going to take more than the period that the client requires. So every time we go for a constructions or we design for a construction, we do consider time as one of the essential things. But unfortunately, of course, it is a fact as well as a real thing that's happening that most of the time we don't meet that thing as we want, as we plan, because all the things happen, it's beyond our control, and we can't control most of the time that things happen, especially change from client, or maybe nature, act of God, or maybe something, cannot avoid by the parties, anything, that will come to the parties or to the project to stop or delay the work. It's very common. Of course, there is no, I never heard that project completed on time. For example, we had started one of the projects with the intention to complete the work within 270 days, but unfortunately, we extended another 53 days because of changes introduced by the client. So it's very, very common. Because of these kind of situations, most of the standard form of contracts, they do speak about extension of time. And it is, in the common law, it is compulsory to have a clause called extension of time and how it's going to be implemented. It is compulsory for the parties. Otherwise, there will be a consequence and those things that we are going to learn. Similar to liquidated damage, most of the time we do think that extension of time is for the benefit of the contractor. People, they do think that liquidated damage is for the benefit of client, but no, in fact, liquidated damage, it gives a lot of benefit to the contractor. For example, when you are receiving tender document, you have identified that employer wants to complete one of the certain projects within certain days. For example, let's take 100 days. But while you develop your program, you have identified that you need another 30 days to complete the project. And you check your contract, where contract says that if you delay the projects more than 100 days, there will be a liquidated damage every day. For an example, let's take 5,000. So contractor identified based on his resource plannings and everything, he had identified that he needs 130 days, but employer wants to complete the project within 100 days. So what he will do, he will identify what is the amount of money he will pay as a liquidated damage for that additional 30 days, and he will include that money within his contract price. This is very common practice, because if anything happens, and if they don't meet the days, or if they don't meet the completion date based on the contract, then they need to pay that amount of money, which amount of money they have already included within their bid, within their tender, so they can cover that. Yeah, similar to that, extension of time also, which is going to give benefit to the employer, because if the employer stop or prevent the contractor to obtain from extension of time, of course the project going to be a state called time large, or we call it prevention principle. We're going to learn everything here. So in terms of extension of time, I would say that it is not only for the benefit of the contractor, but also for the benefit of the employee. But in fact, of course, when you, as a contractor, when you win the extension of time, of course, that's going to be a huge benefit for you, because you are going to, pass or bypass the stage where you're supposed to pay liquidated damage to the contractor. But when you obtain that, you will pass those kind of things. And also, I want to tell you one story, what happened in 1950 somewhere in UK. What happened, two parties agreed to go for a construction. And while they start to do the work, they have identified that one of the pile is not in accordance with the design. So the design provided by the contractor, by the employer, then employer was notified by the contractor, employer redesigned the work and instructed the contractor to go further. But unfortunately, the contract says that the extension of time only can be provided to them if anything they have identified as unforeseeable. So they did not specifically mention that the contractor will be provided extension of time for any changes or any delay occurred by the employer, but it says only for unforeseeable events. So because of that one, the parties raised a concern to the court, and the court says that if the employer did not provide a chance for the contractor to claim or complete the work as he wants within a certain time because the employer distracted them, then the employer cannot apply liquidated damage to them. The very famous case called Peak versus Mechanic. This case law is one of the turning point for all the contract to include extension of time within their contract. The court say that if you are not going to provide them an extension of time, you are going to apply them liquidated damage because of your fault. They are delayed. They can't complete the work on time. How you can apply liquidated damage to them? So in this scenario, court decided that you can't claim any liquidated damage, but the contractor can complete the work within a certain time or reasonable time. That reasonable time, it depends on the contractor's plant, equipment, or resources and availability. So when you are making problems or making a mistake in your contract, something like avoiding including the clause of extension of time, then you will incur huge loss because the contractor will take enough time as he wants to complete the project. So this prevention, we call prevention clause, or we call time at large. So if you do not have an extension of clause in the contract, but you encountered some of the problem or you received some of the changes from the employer. Because of that changes, you need some additional days to complete the work, but you do not have extension of time clause, then you can complete the work as reasonable time, or you can take reasonable days to complete that. So this stage we call time at large. So while I was working one of the projects, I don't want to name it, just I'm giving an example. That projects, they signed with the parties to complete within very limited days because government got to open that place within on certain days. So they signed a contract with one of the design and build contractor, and they did not mention anything about extension of time because they don't want to give any extension of time. Then they started in 2018, and suddenly COVID hit. They got no chance to move further. And contractor almost completed around 70% of the complete work. And now contractor is claiming additional amount of money to cover his work. And he's telling that I'm not going to complete the work as you schedule or as you want, but I'm going to complete the work as I want. Because the contract did not allow, or it doesn't allow the parties to set another completion date. There is no clause saying that the contractor will be provided with the extension of time. So in terms of that one, we are going to learn to close that, As I said earlier, the extension of time is not only for the benefit of the contractor, but also for the benefit of employee. So extension of time is one of the important part that you need to make sure that in your contract you have that clause. Otherwise, the contractor will take enough time to complete the work as he wants. Then that stage we're going to call time at large. It means that the contractor, you fail to give him extension of time. He is entitled to get extension of time. Because of that, his entitlement, as well as you do not have any clause within the contract which is going to provide him an extension of time, then he's going to take enough time as he wants to complete the work. It is going to be reasonable time. So you can't go and argue. Yeah, of course, he can raise that to court and tell that it's not reasonable time. He can take another 5, 10, 15 days to complete it, but he took 100 days. Of course, he can come and prove that because of some so-and-so problems, I was unable to complete the work. So make sure that as a commercial people, make sure that whenever you write a contract or agree with a contract, make sure that there is a provision, extension of time to protect both parties. So next one that we are going to learn something about what is extension of time and what is the stand of FIDIC. Okay, what it says. Of course, in general, employer cannot delay the contractor's agreed milestone achievement or completion achievement. Legally, he cannot, because they have agreed with the parties that to complete the work in a certain time. But if he is going to delay him, he's going to be as a person who is culpable to give him the additional cost. So in the contract, extension of time is a remedy to the contractor. It means it's going to give him some sort of medicine to come back from the ill that he incurred by engineers or the employers or the employers' parties' instructions or delay. Because he is the one who was impacted by the instruction issued by the employer. So under FIDIC 1999, the contractor's remedies are very limited, very, very limited. Of course, the paying party got less obligations than the doing party. The contractor got more obligation, as well as he got no chances to take a decision as he wants. You know that one in the contract FIDIC 1999, employer can terminate the contract for his convenience, but the contractor cannot terminate except one situation. So similar to that, clause 8.4, which is very important clause, which is talking about extension of time, yeah, which is completely different than fourth edition of FIDIC. Fourth edition of FIDIC, even though you can identify many situations they have elaborated under that, FIDIC 1999, it is saying or predicting or showing us what are the situation, what are the all other situations the contractor can handle. So FIDIC says that the contractor is going to be a person who will entitle to get the time if he delayed by employer or employer's party. So extension of time, giving a chance for the contractor to heal from the ill that he encountered by the employer or employer's party. Okay, as the next one, what we are going to learn, we are going to see about two very important cases. The very first one is, which is, as I said earlier, that if any delay that does not impact your completion date, or if it is not going to knock your completion date, then that will not be a part of delay event. Even though you have many other entitlements, you have identified one event, which is, of course, it is delay, but it's not going to delay your total completion of your work. For an example, I'm asking the contractor to change the color of tape. The contractor started to work or started his activity on certain days, and he got float. Float means, you know, he can move his activity from back and forward with a certain days of margin. It's not going to impact the completion date. So he can start his work 10th, or he can start his work 15th, but it will not make any impact or knock-on effect to the completion date. So I'm asking the contractor to change the color of tails before he ordered. He identified that ordering this tails color may delay the activity, but not delay completion of the project. Then the contractor is not entitled to claim them. So this very first case, which is talking about that, the case versus Kenny Constructions Private Limited was SOPO, which says that if any of the activities, which is itself, you know, it's been delayed, but it's not impacting the total of the work, then you can't claim any delay. Then the second one, as I explained earlier, the principle between peak as well as versus McKinney, which says that if you do not have a clause or if you do not have a term in your contract which is giving a chance for the contractor to extend his work because of the client problems, client instructions or changes, then the client cannot implement liquidated damage to them. So these two cases are very important. Most of the time, the contractor, they do come and claim for some of the cases telling that, no, we have an impact, that activity delayed. So what happened in one of the projects which I worked, the contractor said that they have a delay in so-and-so activity and they immediately they have issued notice. Then I asked them, submit your window analysis with a 28 days window so we can see whether this activity, delay of this activity actually impacting the final completion date. Then they started to develop that and they came back to us and say that they're going to withdraw that notice because they did not identify an impact to the final completion date. Because that program, that activity will consume float of the work, float of the projects, and that will vanish without any problem. Similar to that second one, of course, extension of time, as I said earlier, in one of the very biggest projects of government, they set up certain days, but unfortunately the contractor was unable to complete it because of COVID. And the employer wants the contractor to complete it immediately within certain days. They say that, no, we are not going to complete it as you want. We are going to complete as we want because you do not have extension of clause within your contract. So make sure, even though you are going to issue LPO or PO, whatever it is, you make sure that if it is a service or something, make sure there will be a clause to protect yourself and protect your work. Okay, so these are the two major works. So I have included one of the example. You can see that the parties agreed. They very clearly say that you need to start the work on this date, you need to finish it, no extension of time clause within that. And we will pay you on this date 50%, on this date 30%, on this date another 10%, and the 10% going to be after you complete the work. They have released all 90% to the contractor because they have set a certain days to release the payment, not against any progress or milestone. So contractor received the work, money, they have executed only 70% of the work. Now, because of COVID, they are going to take enough time as they want to complete the work. So make sure these two cases are, you should keep in your mind whenever you draft your contract or whenever you agree or sign a contract or process or review any of the contract. So make sure that there will be enough clauses as well as protection principle. So the next one, what we are going to learn about the type of construction delay. In the industry, there are mainly 3 types of construction delay. Of course, people, they do tell another delay also, but I'm not going to discuss that because it is not delay, but it's a prevention method. So I will talk about that later too. So in the industry, we have mainly 3 types of delay. The very first one is critical versus non-critical. Critical mean, which is, as I said earlier, when you make a change to any of the activity of the construction as contractor planned and you agreed, if you're going to make any changes to any of the work, that work will hit the final completion date. So for an example, when you prepare, guys, kindly please switch off your mic as well as video, please. It is distracting me too. Okay, so when you start your work, when you give instruction to one of the activity, that activity may.
Asmi, you are not share your screen.
Okay. So please, guys, please don't switch on your mic or camera, or don't try to share anything, please. So when you start to have impact or give instruction to any of the activity, which is linked with the critical path. Critical path mean, before we go into that, let me explain to the critical path mean the contractor, they do develop plan. In any of the program they can use, and they can develop the plan, what are the activities, when they're going to start and when they're going to complete. So they can identify a link or chain of activities which is connected. If you start one activity, you need to finish it before you start other activity. Or you need to finish, or you need to start one activity before you start other activity. Something like that, where these activities are linked. If you tap or if you change one of that, then that will impact all the way. Finally, that will change the completion date. So that's what we call critical path. So when you are analyzing critical versus non-critical, the activity which will be impacted and that will impact the completion date, we call critical activity, critical delay. Then non-critical means something like, I'm going to instruct some sort of changes to them, but that is going to change the activity start end date, but that will not impact the completion date of the projects. For an example, as I have mentioned earlier, changing color of tiles or something like that, or asking contractor to provide one additional document. That will take 2 or 3 days, but it's not going to take more days, or it's not going to impact the completion date. So that's what we call critical versus non-critical. In terms of excusable as well as inexcusable. For an example, excusable delays that's being very clearly mentioned within the contract. For an example, the delay which can be excused, which will be provided or which will be apologized, which will be excused by the client. Normally, the client is telling contractor to do additional excavation. The contractor coming back to you and say that, the employer, you're asking now. Guys, can you all see my screen?
Yes. Yeah, we can see.
Yes.
Okay. So now you requested me to change or do additional work. Of course, we need additional dates. So then employer will identify, okay, that can be excusable because I asked him to do additional work and I'm going to excuse him. Okay, go ahead. Then inexcusable mean something there contractor delay from his side. It's not from my fault as an employer, but his fault. For an example, he failed to comply with the histogram to bring the main power as he required to start the work. For an example, I can say, recently, one of the contractor, while I'm working with them, they're supposed to start the steel erection on 19th of May. But unfortunately, because of some sort of fabrication issues and many other things, the contractor delayed until 2nd of June. So we have immediately notified to the contractor as an early warning, as well as lack of progress. We have notified to them and say that we have delayed your activity to so and so days, which is on the critical path. And if you are going to come back to us with an intention to claim any additional time, we are not going to provide. And we will keep this delay from the contractor as an evidence to counter argue with you. So we notify to them that this delay is not excusable. It means that it's from your pocket, you did the wrong, you need to survive for that. So that's what we are telling to them. So that's kind of thing that we are calling inexcusable delay. The next one is compensationable versus non-compensable. So in the contract, of course, FIDIC says many clauses, and it is telling certain clauses, even though the employer is going to give you extension of time, additional days to complete the work, they will not provide you additional cost that you are going to incur. The parties are agreeing for these things. If you are a talented person, or if you want to agree with the employer, of course, you should agree for a cost also. But most of the time, of course, we do identify those things as a risk because they are going to give only extension of time, not money. Then we include that as a risk and that amount of money within our bid. So in the contract, it is telling that some of the cases we will give you money, compensable, and some of the cases we will not give you money. The very good example, I can say that adverse climate condition. For that one, the FIDIC says that, of course, we are not going to give you money, but we will give you extension of time. So in terms of that one, we are going to see what are the possible metrics that we can have in the construction industry. So there can be 4 possible metrics, such as the very first one is non-critical delay. As I said earlier, I'm changing very minor thing, which is not going to have a knock-on impact to the extension of completion date. So those are the things that what we call non-critical delay. The second one is we can tell critical, excusable, and compensable delay. It means that, of course, as an employer, I'm instructing the contractor to do additional work, additional excavation. Of course, that additional excavation will impact the contractor in terms of completion date. So I'm going to excuse that delay, as well as for that additional work, I need to pay him money because he's doing additional work based on my instruction. So that's going to be compensable, as well as that's going to be a critical thing because that is impacting the completion days. So the second type of matrix, we can say that the contractor can claim critical, excusable, and compensable delay. While I was working for
Hello, can anyone hear?
Yes, voice is breakdown.
Yeah, of course, that's why.
We can't hear you. Sir.
Poor network issue, I think.
so I'm sorry for that. So they have issued suspension notice for one certain particular area. Because of that one, we identify that some of the subsequent work cannot complete it. So what we did, we immediately issue the notice to the employer and say that the employer, you ask us to suspend starting work on that. Because of that one, so and so work going to be delayed. So it is your problem. So it is excusable. And you are delaying us because of that one. Our people are idle, as well as they are going to be mobilized for another project or maybe another work, and they need to bring them back. So there will be a cost. So that's going to be compensable, as well as because of your suspension, we can't complete the whole projects as you plan, because we are keep dragging, which is going to consume all the float, and eventually that's going to impact our completion date. So we have immediately issued the notice and we won the case. And the third one is critical and non-excusable. So as I said earlier, the contractor did something wrong, which will impact the complete critical line of the company, of the program, of the projects, and I'm not going to excuse that. So as I said earlier, for the start of steel work, they delayed from their side. Because of that one, it delayed the complete program. Because of his fault, I'm not going to pay any money from my pocket to him. So we call that as critical one. Of course, it is impacting my program, but I'm not going to give him money. It is non-compensable or non-excusable. And the final one, we can say that critical, excusable, but non-compensable. One example, as I have mentioned, within the FIDIC, they have mentioned that because of exceptional adverse climate, if the project's delayed, the contractor will be provided by extension of time, but no cost. It is simply telling that, of course, because of this adverse climate, the projects will be delayed of delivering a completion date, as well as it is excusable because of the act of God, and we are not going to pay you money because we have agreed in the contract. So these are the four major types that's being claimed by the contractor in the construction industry. Of course, you can identify many, complex metrics, but these are the major four being claimed by the contractor. Let's move to the next slide to see what is prolongation cost. So after the prolongation cost only, we are going to move to the FIDIC, what FIDIC says about extension of time. All these three slides just to give you an idea about what is delay and what are the type of delays being claimed and what is prolongation cost and how they claim the prolongation cost. So in terms of prolongation cost means simply it is an amount of money that you are giving to the contractor to bring him back to the position where he was before this event happened. For an example, I'm asking the contractor to extend or do additional work of excavation. Then the contractor started to do the work. Then for that work, he needs to take another 25 days. And he's telling that for that additional 25 days, I'm going to incur cost in terms of machineries, manpower, and my additional services, many other costs I may incur. So he's going to come back to you and say that, the employer, you asked me to do additional work. I can't do that for free of charge because I'm incurring costs. You need to pay those costs. So for this extended period, or we can say prolonged period, the contractor entitled to receive money. It depends on the contract, of course, obviously. The contract should say what are the scenarios the contractor can claim money. We are going to see what are the clauses entitling the contractor to get his extension of time and to get money in terms of what cost, whether it is with a profit or not. We are going to see those. So unless specified in the contract, compensation for delay should only be paid for the work or the actual work that they have executed, or the actual time that they have lost, or the actual loss that they have incurred. It is very common practice that the contractor, they do claim all the cost, including their profit. But the contract should specifically say whether the contractor can claim additional cost or not in terms of profit. So we all need to make sure that we are aware about those things. In terms of prolongation cost, the contractor can claim direct cost. Direct cost mean those are site labors, plant, and subcontractors payment. Those are directly involving in terms of executing the work. The contractors must keep all the records in all situations. They need to bring the actual thing to show you that, of course, this is the actual cost that we have incurred. For example, in one of the projects, what we did, we gave an advanced copy of one of the drawing to the contractor and asked him to develop a cost model for that design. Then after certain days, we issued instruction to them to omit that work from their work. Then the contractor came back to us and said that based on our previous advanced copy instruction through email, we have started to develop some sort of model. But suddenly you have instructed us to omit the work, but we have already incurred some sort of cost in terms of developing those things. Then we say that, okay, fair decision. Submit your things in terms of timesheet and your people's working, finalized documents and outputs. Those documents submit to us. Then we can check it. If it is actually, cost incurred work, then we can pay to you. So similar to that, the contractor can claim very first things as a direct cost. The next one is they do often claim indirect cost. Indirect cost mean, which is required for the contractor to successfully deliver the projects, but it's not directly involving within the projects. For example, I can say that anyone with any idea, of course, as a commercial professionals, we should know that one. Of course, very often we call what? Indirect cost.
Head office cost.
Exactly. So we call it overhead. Okay, it's maybe head office cost, or maybe the people that's working behind the projects just to deliver these projects on time. So those are the costs also the contractor can claim. In addition to that, the contractor can claim financial charges. So most of the time, financial charges, they do tell that because of the extension of time, I need to maintain or extend my insurance. For example, normally they do submit their performance security for a certain period until they complete the projects. Now you are asking them to do additional work. Then they need to extend their insurance or bank guarantee, extend to the certain period, then that will cost them. So those are the things that they may claim. Or else we can say that they might have taken a loan from the bank to start the work. Now you are asking them to extend the work, which is going to incur additional costs in terms of they need to overdraft, or maybe they need to extend the period of overdraft, something like that. So additional financial cost also they can claim. The next two things, it is arguable things, whether profit and loss of profit. These two are one of the most argued things in the industry, whether the contractor can claim or not. From my understanding as well as my practice, of course, I would say that the contractor is entitled to claim profit. Because I would say that as a contractor, I might have moved all my equipment at the date of completion to some other projects, and I might have, or I can earn profit from that project. Because of your additional work and because of your extension of time, I'm keeping my equipment, I'm keeping my main problem, I'm keeping all other things. So why should I want to invest my things as well as stuff here without getting profit? So in terms of that standard contract, form of contracts, most of the time, they do provide a chance for the contractor to claim profit. But of course, it is still arguable things. Most of the time, when people go for bespoke or maybe tailored contract, they do remove these kind of things from the contract. If you are a commercial person, you should make sure that for certain things that you need to claim your profit too. In terms of loss of profit, it is one of the very minor things that people are claiming. Of course, what they are telling that because of your instruction, I lost my profit of earning somewhere else. As I explained earlier, I might have moved all my equipment to some other projects, and that project will give me profit. That project will give me profit. Now I'm keeping my equipment and everything for months and months without any profit. So why I need to keep those things? So these two things, of course, from my understanding as well, my reading and my practice, I'll say that, of course, we need to keep it. So if I'm not wrong, in one of the charted question, they asked whether the contractor is entitled to claim this profit or not. So the question asked in order to check whether the party or the person who's answering is clear enough about the claim of professional profit. Then the answer is yes, because why do I need to spend my equipment's manpower's time here for the sake of nothing and get nothing and deliver your projects? So you need to tell them, of course, I am entitled to claim my profit. So these are the major things. Of course, you can identify many other things that the contractors claimed, but these are the major things that you need to make sure that you are including within your claim, or you are receiving from your contractor. Then you need to, if you are receiving from your contractor, you need to make sure that they are claiming these kind of things as an important thing. You should be very fair. Yeah, in all situations, you should not tell that contractor did not claim, okay, leave that. You should not be like that. If you are a contract administrator or engineer, you should be very fair. That's what FIDIC also says. So you need to make sure that. In terms of claim preparation cost, of course, preparing claim is one of the specialist things. Of course, if you are an experienced person, of course, you can prepare for your company. But most of the time, people appoint special contract special person. For example, the GCC, HKA is one of the specialists for that. So they do appoint for work. So if you are going to appoint them, you're going to incur cost for those things. So there is always a question mark in almost all the industries, whether they can claim that amount of money or not. I would say that very first thing, it is depend on your contract. The first thing that you need to check your contract, then you need to have an agreement with the party. If the party is telling that, and you are identifying that they are entitled for this excusable delay, and that delay gave you benefit as a client, then you can agree with them to give some sort of, you know, in a sympathy, you can give some sort of money for those things. But you should be very fair, and you need to check your contract, whether your contract avoiding those things and party agree, or it is clearly saying that we need to give that money to them. So these are the major things, major problem that we are identifying, whether what kind of claims heads that the contractor claims from us. Then we need to check in terms of documentation as a contractor, what are the documents I need to submit? In all the way, extension of time, which is very, you know, sensitive claim. So all the way, the client or the client representative or client agent, they expect you to be very perfect. So whenever you submit a claim to the client party, make sure that you are submitting all the contemporary records. Contemporary means what are the records that showing that this delay incurred time as well as cost, then you need to submit everything. For example, the delay analysis, which we have incurred, as I said earlier, for that, we have submitted 2,100 pages of document, including everything. Timesheet, additional payment, subcontractors, additional payment, agreement, you know, WIR, MIR, many documents we have included to prove that, of course, actually, we incurred lost in terms of time as well as cost. So I have listed some of items to show you that what are the things that you need to submit. You can see many things: timesheet, updated program, payment applications, labor hours as well as record, engineer's payment, contractor's estimations, program, many things. So whatever the record you can secure, you need to secure, keep it perfect and keep it updated and submit them with your interim or final claim. Okay, these are the summary of extension as well as prolongation cost. Now let's move to the claims. Okay, I think we have one more slide in terms of defensing claim. Okay, so when the contractor make a claims to you, you may defend those things. In order to defend those things, you will have mainly five, I would say that equipments or tools to defend it. The very first one is including a clause within your contract that no damage clause. You're going to include within the contract that any damage happened to the projects, we are not going to provide any cost, but the time, that's going to be different things. We will not pay anything. If you include that one, of course, if the party agree, they can't claim it. The second one is time is of the essence. Of course, it is very peculiar. Of course, I know that one, including this clause or agreeing in the contract. Time is of essence mean you need to complete the project within exact time, regardless of what are the situation you are going to encounter. Regardless of that, you need to complete that. Of course, some of the territory, some of the law, it is restricting these kind of things. It depends on your country as well as depends on your contract. If your contract says this one, of course, at any cost, the party needs to complete the work on time. And the third one is time bar clause. Of course, we are very familiar with that. Every time we are telling that you need to submit your notice within 28 days. You need to submit your fully detailed claim within 42 days. Or you need to submit your interim claim every month. So we are telling them a time bar. The main purpose of time bar is to make aware the employer that we have so-and-so incidents which may impact the completion time or clause. Whenever you update him, he will work and he will identify the remedy for that. He can take immediate action. If you don't notify him, and at the last minute, if you are coming to him and telling that the employer, because of so-and-so, I got 5 million additional cost, then he will be shocked. So the main purpose of time bar is to make sure that the employer is aware about the incident. So if you have a time bar clause within the contract, and if you don't see the contractor is obeying them, then you can simply tell them that you did not fulfill the time clause or time bar clause that we have mentioned. Because of that one, that's not going to enforce us, and you are not entitled to get the money. Of course, different countries' law, jurisdiction says different things. But if you have an express term within your contract, then that will overrule everything. And the next defense that you can use, force majeure. Of course, if anything happened and you have identified that is force majeure, then you can use that clause to defend that, and you can give him extension, but based on your contract, you can give him cost, or you can avoid to give him cost. And the next one is concurrent delay. Concurrent delay is also one of the defensing tool. When contractor comes to you and say that I have 100 days delay, then you're going to tell him that, dear contractor, of course, don't you know that I have notified through so-and-so letter that you delayed so-and-so work, where that delay and this delay happened within same period time. Because of that one, based on our contract, you are not entitled for that. It depends on your contract, but you can use this as a tool. You can use concurrent delay as a tool also. Okay, so these are the major 5 defensing tools that you can use to defend your contractor's delay. If you are a contractor, you need to make sure that you are following and you are complying with all these clauses. Okay, let's move to the next one. So this is the very first one that we are going to see about what clause 8.4 says in terms of extension of time. So extension of time, FIDIC says that it is, of course, the contractor is entitled for certain things. Not like fourth edition of FIDIC. In the FIDIC 1999, it very clearly says what are the situations the contractor can claim his extension of time. And each and every clause which is telling that the contractor is entitled for extension of time very clearly says whether the contractor is entitled for cost or cost plus profit, or is entitled for nothing. So 1999 removes most of the ambiguity which we encountered from fourth edition of FIDIC. We all know that one, the very first clause, 8.4a, says that any variation or other substantial change in the quantity of an item of work will give a chance for the contractor to claim additional time as well as money. So variation, we know that one, clause 13 very clearly says what are the items that will be considered as a variation. Addition, changes to the quantities, omission, changes, sequence changes, many other things they are telling. Yeah, so based on that changes, you can identify whether this contractor is entitled for variation, because of the variation, whether he's entitled for extension of time or not, you can identify simply. The next one is, it says in a single phrase, it says that any other substantial changes. Can anyone tell me what is substantial changes? If we are aware about that one, what is substantial changes in FIDIC? Okay. So FIDIC, it's not clear what is the amount of additional work, or what is the additional quantity we are going to consider as a substantial quantity. Even though it's not said, we can see that under clause 12.3 evaluation, yeah? Under 12.3, you can say that clause A say that any work more than 10% or 5% will change the rate. Can we consider that as a point of rigor to consider substantial quantity, or the quantity which the contractor can consider to claim extension of time to his program? Can we? No, we cannot. Because 12.3, most of the time people are linking these two. That's what I'm telling you. 12.3, it's very clearly saying it is for the purpose of evaluation. So when you're evaluating any variation, if we have identified the quantity is more than 10% or 5%, whatever the quantity percentage that you're going to agree, if it is more than that, you need to revise the rate. You need to sit down with the contractor and revise the date. It did not say that this quantity is enough for the parties to claim additional work. Because I'm going to instruct the contractor to do one of the additional work, which is in terms of quantity, 25% of the initial quantity, but there won't be any impact in terms of additional time of cost, additional time of sale. So he's not entitled to claim it. So in terms of substantial quantity, the contractor is the one who can perfectly identify whether the amount of quantity which will impact their extension or their completion date. Then they can submit their record and their proof to show you as a client or consultant, dear contractor, you have changed 100 quantity which did not change, did not impact our progress of work. But when you change that to 20,000, then that impacted our completion date. Because of that one, we need extension of time. For an example, you ask one of the contractor within the contract to deliver one generator for the project. Now suddenly you're asking them to deliver, to provide or install another 3 generators. Then the contractor will simply come and tell you that, dear contractor, dear employer, based on your requirement, the generator is long lead item. As you have instructed today only, that is going to take 9 months to deliver the item, which will impact our completion date. You are telling them to install one generator. Then he will come and tell you that, the employer, you're asking me to bring one generator. Of course, that will, guys, someone is sharing your emails here. Dinakara, please. So that's going to tell, they're going to come and tell you that it's not going to be any impact. Let me share my screen. Guys, please. Okay, so they're going to simply come and tell you that this quantity is not impacting my problems, and this quantity is impacting my program. So substantial quantity is depend on the instruction and the contractor's identification. So very first point of FIDIC says that you can consider to give extension of time for variation or extension of time for substantial quantity. So these are the two things. So the very first one, variation, you can consider all the variation under 13. Then for the substantial quantity, you need to speak with the contractor, sit down with the contractor to know what is the amount of quantity that really impacting this program. So these are the two major things that you need to consider under point number A. The second one is point number B. Point number B says that any other clauses within the contract, any clauses you have identified, clause number 20, clause number 19, clause number 1, clause number 0, something giving a chance for the contractor to claim additional time. So 8.4b says that any other clauses saying that the contractor is entitled for extension of time will give a chance for the contractor to identify and claim his extension of time. In terms of FIDIC, other than clause 8.4, there are another 15 clauses which is giving entitlement for the contractor to claim his extension of time. You can see what are the clauses. 1.9, yeah, which is delay of drawings or instruction. 1.2.1, right of access to site. There are plenty of clauses. I have listed all the clauses and I have marked whether these clauses are giving chance for the contractor to claim extension of time or not. I can tell you one example to 1.9, simple example. So in one of the program, approved program, baseline program, the contractor highlighted that for the crushing of the work, we need to receive an instruction to start our crushing on or before 13th of so-and-so month, 13th of October. But unfortunately, the employer still in a dilemma whether they want to start crushing now or later. Then they delay this program until February 2nd. Then the employer identified that, yes, we need to start crushing. They have issued instruction to the contractor. Immediate after that, the contractor send a notice to the employer, say that the employer is supposed to issue this instruction way early, October, November period, but you are issuing now, which is impacting our program. So when you delay any of the instruction, of course, that's going to delay complete program. So the contractor will come and get time. So as I said earlier, not like fourth edition of FIDIC. In the fourth edition, they are telling many places that this will give extension of time. This will give extension of time. But under evaluation, it did not tell that whether these clauses are entitled for the contractor to claim additional time or not. Like FIDIC 1999, point B says that, of course, any other clauses saying about extension of time is going to giving it's giving chance for the contractor to claim extension of time. This exact clause is not in 4th edition of FIDIC. So this FIDIC was developed with very good intention. As also, whenever you submit your document to the client, you need to make sure that you are complying all other clauses where contract say that you obliged to follow or comply. So you need to make sure that in all situations that you are following other clauses before you ask them to give extension of time. Otherwise, the employer will use his tool as a defense of your claim. As I said earlier, while I was working one of the projects, what happened? The contractor failed to notify the employer that the instruction, we have issued one instruction, contract administrator's instruction to the contractor. Contractor took that instruction and thought that all the instruction will have cost and time impact. Then they did not issue notice. They failed to issue notice within the time frame, and they came back and said that we have time and cost impact. Then we say that why you did not issue the notice, because your contract very clearly says in any situation, if you incur cost or time, you need to notify to us. Why you did not notify? Then he said that no, we thought that if it is an instruction, automatically it is going to be time and cost impact. Then I said that who knows that? We don't know. From our perspective, we have maybe time and cost impact, but you are the contractor. You are the one who should know, or who is well know whether this instruction will impact in terms of time and cost or not. So you should notify to us. You should not take all the CAI, contract administrator instruction, as an extension or additional cost. So you should be very careful. Whenever you go through or comply with any of other clauses, you need to make sure that you are complying with other clauses too. Okay, so these are the clauses which is giving chance for the contractor to apply or issue a notice telling the contractor, telling the client that as a contractor, I have impact in terms of time. I'm entitled to claim time. Okay, you can see in total it's around 20 clauses. If you remove all these 8.4, which is talking about extension, then 15 clauses, other clauses, which is giving chance for the contractor to claim. For an example, delay of drawing or instruction, or failure or delay of giving access to the site, or fail to cooperate with the contractor, or fail to approve the setting up, or maybe different or issues with setting up, or maybe unforeseeable event. Many other things you can see that. So each and every clause is drafted with the intention to have a fair deliverable between both parties. So you can see many clauses saying that the contractor is entitled. So each and every clauses telling you can apply a notice under 20.1 to reserve your rights in terms of time and cost. So whenever you issue a notice, you need to make sure that you are complying within the time frame. You are checking your contract that it did not say that no damage clauses. It did not say about time is of essence, or it did not say that you are not entitled, something like that. You need to make sure. So FIDIC says very clearly, it did not talk about a concurrent delay. It doesn't talk about time is of essence. It doesn't say that you are not entitled to get any delay damages. If you are going to go for any other contract, which is tailored contract or maybe bespoke contract, then you need to be aware about the clauses that he is giving you entitlement in terms of time and cost. So the next point says about FIDIC, in FIDIC, it says that exceptionally adverse climatic condition. I want to tell you one very important thing. You need to read the clause very carefully. It says that exceptionally adverse climatic condition. It did not say that adverse climatic condition. It says that exceptionally adverse climate condition. So you are working in a project, for example. You have identified that the rainfall of this month is higher than, or it is very higher than last year rainfall of the same month. Then do you think that you can claim extension of time from the employer? No. Under FIDIC, it should be exceptionally adverse. It means that, for an example, let's take an example. In the history, you have identified that very severe rainfall will happen once in a 10 year. Then you have identified in your project period, within 1 year or 1.5 year or 2 years period, you have identified that kind of rainfalls happen 2-3 times. Within that 2 year of your project period, this kind of rainfalls happen 2-3 times. Then you can consider that as an exceptionally adverse climate. It should not be adverse climate, but it should be exceptionally adverse climate. The adverse climate should be exceptional. So then only you can go and claim, or you can ask for a claim. And also you need to point out one more thing. FIDIC did not tell that this is only for rainfall. It is telling that it is exceptionally adverse climatic condition. In terms of climatic condition, you can consider anything. Exceptionally adverse wind, exceptionally adverse weather in terms of hot. You can consider anything. It's not only for rainfall. Remember that. Okay, make your mind clear that it is not only for rain, but also any other climate which is exceptionally adverse. For an example, while I was working for one of the airport projects, what happened? Because of severe wind condition, the crane operator was unable to operate the crane. So we check our contract. It says that it should be exceptionally adverse climate. Then we recorded within that month how many times this event happened. We have identified only 2 times. We check our previous histories from the relevant department and authorities, and they recorded that every month normally that will happen 3 to 4 times. So this time it happened only 2 times. It is even not adverse. So in order to claim additional time or cost, then that should be exceptionally adverse climate. For example, within that month, around 20-30 times it happened. Then we can say that it is exceptionally adverse climatic condition. Okay, so you need to be very careful when you apply or when you receive claim in terms of in this clause. The next one is, which is about unforeseeable shortage in the availability of personnel or good caused by epidemic or government action. Normally, in epidemic or pandemic situation, of course, governments or authorities, they do make restriction. We all know that one, what happened last 2 years. The governments as well as authorities made restriction to you to start and continue your work. So in this kind of situation, we have identified mainly 4 very serious scenario where you can apply and use this clause. In terms of very first scenario, we can say that the change of law was not the issue, or the government did not ask you to suspend your work, but one of the ministry asked you to take precautions. So within your contract, you can claim only change of law, which is avoiding you or stopping you or restricting you to start your work or continue your work. So you check the contract, which is not giving you a chance to claim additional time and money, because the government did not issue any change of law. But what happened, because of the health ministry's instruction, the parties started to work from home, and the authorities started to work from home. So you identify or you face delay by authorities. So rather than claiming your extension of time under clause 8.4b, what you can do is 8.4d, what you can do is you can use clause 8.5, which is telling that delay by authorities. You can use that clause to claim your extension of time. The next scenario, we can say that the government did not instruct anything to stop the work. The health ministry say that you need to take all the precaution. Then the employer as well as employer representative started to work from home, which is delayed or impacted your program. Then you can use clause 8.4e, of course, which is saying that any delay caused by employer or employer's party. So you can use that clause where you can't claim through pandemic, or you can't claim that through change of law, but you can claim that through 8.4e, which is giving you chance because of the employer and employer's party delay that you can claim extension of time. The next one is, next scenario, the government instructed you to stop working, and they are telling that you can't start or you can't continue any of the construction. Then simply you can claim that under 13.7, which is talking about adjustment for the change of law. The FIDIC clause 13.6 says that if anything happen or anything change, any changes to the law which is impacting you in terms of time and cost, you can claim that amount of money. For example, in KSA, they have a protocol called procurement and tendering law. They have bylaw, which is giving a chance for the government entities to extend the work if the work is delayed by government as well as authority. So even though your contract did not give you chance, the government law or the country law can give you chance to get your extension of time or additional cost. So you need to make sure if you don't identify any clauses which is enabling you to get a time for that, then you need to check the government law or you need to get your legal advice how we can claim it. Of course, normally throughout this epidemic or pandemic period, the government or the contract, they do normally give a chance for the parties to obtain their requirement. If you do not have such a clause, as I said earlier, the contractor would say that no, we are not going to work as you want, we are going to work as we want. So the project gonna be time at large. Time at large means whenever he wants, he can start and complete the work within a reasonable time. So you need to make sure that your contract is giving. So in terms of this kind of situation, if it is epidemic, pandemic, or government action, then you can claim, if there is a change of law, then you can claim under 13.7, adjustment to the change of law. The last one is, it's about force majeure. I just want to ask one question. Can we consider force majeure as a chance for us to claim additional time and money?
Yes.
Anyone? We
Yes.
can? Can we?
No, we cannot. No.
Okay. Okay. So in terms of contract, let's take FIDIC. FIDIC very clearly says under 19, if you go and take the books and see that, it says that if a situation which can be avoided reasonably avoided by the parties, then they are not going to entitled to any of the extension of time or cost. So what most of the time health ministries or the government say that If you're going to take all the precautions of the coronavirus, COVID-19, then you will be protected from this virus. When you apply this clause, force majeure, for COVID-19, the employer may come to you and say that under clause 19.1 V5, which say that if you can take a reasonable protection or reasonable care, then you can't claim force majeure relevant entitlement. So the employer simply say that you can't claim it because you should have implemented all the required procedures to do your work and avoid the things. But because of these precautions, your productivity as well as your manpower outcome will be destructed. So you can claim that amount of money or the less of your productivity serving, you can claim that through change of law or government authorities instruction, or you can claim it as a disruption claim. It depends on how. Maybe the government say that if you are going to work in a construction, you need to follow certain procedures. Then based on the procedure, you start to work and you have identified that your productivity is less. Then you can claim for change of law. Then it is not a change of law, but a government or the authority is telling that you need to take precaution in all the situation. Then you can claim your additional time and money throughout clause 8.5b. Okay, so you need to identify the scenario which is giving you a chance to claim the extension of time under FIDIC. So these are the major 4 scenarios that you may incur or you may encounter when you handle something like epidemic or pandemic situation. So I have made very small note bottom of the slide just for you all to understand what is endemic, what is epidemic, what is pandemic. So you can read those things and understand what are those things. And point E, which is telling that any delay by the employer or employee's party, as we have seen earlier. The point E, again, it is reflecting, it is telling that if you are delaying your contractor because of your action, is going to incur additional time and cost. You need to pay for that thing. So the case law between calls versus Northwest Metropolitan Companies, which says that the employer or the employer's party, they cannot stop or delay the contractor in terms of completing work as agreed. They can't ask him or they can't tell him to do additional work without giving extension of time. So the employer or the employer party, if they are interrupting you and delaying your work, then you are entitled to claim the money. The clause very clearly says, 8.4E says that if you incur any delay by employer or employer party, for example, in one of the contracts which I work, which very clearly say that you need to review, as an engineer, you need to review the shop drawing or the approval within 7 days. If I delay that one, and because of that delay, the contractor delay his construction activity, then at the end, eventually that impacted completion date, then contractor, as a contractor, you can use this clause and say that the employer, because of so-and-so clause, pursuant to this clause, your engineer on this date delay the item in delivering that. We are keeping record of this and we will submit our interim or full claims to you. So this clause is giving you chance to use when you incur cost or time or delay to your program by employee's party. In terms of next point, which is telling that what are the clauses that the contractor is entitled to claim the money. So many clauses giving chance for the contractor to get the money back. Okay, but only some of the clauses are giving the chances for the contractor to get the money plus profit. Okay, in terms of basic of calculation of compensation for prolongation, we need to make sure that the contract is expressively telling what are the situations the contractor can earn profit or can claim profit. In terms of FIDIC, I have listed all the clauses which is telling that where, when, what kind of things the contractor can claim. So if you see here under clause 1.9, point number 1, clause 1.9, the contractor can claim cost plus. I have put plus to remind you that that plus means his profit. It is showing very clearly that the contractor can claim profit only in these situations. If you are a negotiable contractor, at the time of contract, you should negotiate it with the employer in what are the other situations that you can claim your profit. Or else you need to define within the contract that the definition for cost is equal, cost mean any other actual cost plus profit. So all the costs that you are going to mention throughout the contract are going to be cost plus profit. Or specifically for each and every clauses, you need to mention that what are the clauses that you can claim profit. In terms of FIDIC, which is telling that what are the clauses the contractor is entitled to claim the profit plus cost. So I have highlighted here, you can see that whether they can claim cost plus or cost. And some clauses, it says that even though they can claim time, they can't claim cost, especially when it is unforeseeable things. They can't claim cost related to that. So if you are a person who is negotiating with the employer or the contractor, you need to make sure that you are fairly considering the thing that you want as a profit. So you can go through this list and identify the items that is entitling you to claim cost plus your profit, or only cost, or no entitlement to cost. Okay. And the next one is we are going to see what is the procedures. I want to tell you two kind of procedures. One, the very first one is interim claims. Most of the time, as a contractor, we cannot fulfill the contractual requirement in terms of collecting fully detailed information to substantiate our claim. So immediate after we identify that we have a time cost impact, what we do issue notice under 20.1, and we say that this is within 28 days, and we will submit our interim or fully detailed claim in accordance with the contract. FIDIC says that, very first things FIDIC says that the contractor, upon identifying the event which is going to impact him in terms of time and cost, he should raise a notice within 28 days from that event. He needs to raise a notice within 28 days. The last day for him to raise the notice is 28 days. So I have mentioned here, within 28 days from event occurrence, he needs to raise his notice. Then after he raised the notice, within 42 days, he needs to submit his fully detailed claim. Most of the time, we do misunderstand this kind of work. Of course, while I was working for one of the projects, one of my contract managers said that it is just an interim claim. We don't want to attach any information, just write a letter telling them that our event is continuing and this is interim notification. FIDIC is very clear. You can see here, I have highlighted this. The FIDIC is telling that within 42 days from the event, you need to submit your fully detailed claim. And if you are incurring monthly or continuous impact to your program because of this event, the document that you have submitted as a fully detailed will be considered as interim document. It did not say that whatever the things that you are going to submit will be considered as a interim. What they are telling that after 42 days, you need to submit a fully detailed claim. And this event is making you continuous impact. Then you can notify the employer, the employer, see all the fully detailed claim up to the date that we have collected. And this event is an continuous impact. It is with a continuous impact to us. Because of that one, we are considering and submitting this as an interim claim to you. You should attach a detailed information to them in terms of to the date, impact to the program, to the date, all the contemporary record that you have collected, to the date, all the timesheet, all the cost calculations, whatever the things, estimation, whatever the things that you have executed, you need to submit. You can't simply issue a letter and say that, please consider this our notice for all our interim claim. You can't tell them. Unless otherwise, in your contract, you clearly changes. FIDIC very clearly say that from the event within 28 days, you need to boom issue the notice. Then from the event within 42 days, you need to issue fully detailed claim. And if you have continuous impact from this event, then you need to notify this fully detailed claim to the date is an interim claim. Then after that, every month, you need to submit your updated interim claim to them. You need to tell them that, okay, first month you have submitted after 40 days, then after that, next 28 days, okay, maybe 30 days or 20 days, it depends on your contract. So next 28 days, you are going to submit additional. So throughout these 60 days, we got this kind of impact to the program. This is a cost incurred by us, and this is the impact. All those things, we are going to give that to them. So we are keep telling them, we are keep notifying them, these are the costs that every month that we are incurred. Then FIDIC says that after that, once you have seized the event, you have identified the event is end, it's done, no more impact, then from that date, within 28 days, you need to submit your final fully detailed claim. So what you need to do, very first within 28 days notice, then from the event date within 42 days, an interim fully detailed claim. Then after you issue the interim fully detailed claim, every month you need to update and submit that. Once you identify the event is ceased, then within 28 days, you need to submit your final fully detailed claim. Once you submit your fully detailed claim, then employer or the employer's agent will take another 42 days to review that, and he will call all the people to the meeting, and he will try to settle that amicably. If he cannot, if the parties are not willing to come for an amicable settlement, then he will issue his determination. Under 3.5, he will issue determination. I want to ask one simple question. If I'm going to issue interim claim to the employer, contract administration, is he obliged to issue interim determinations or not?
Unless and otherwise, the extension of time is approved, he cannot give his determination.
The scenario is we have no approval for extension of time. I keep submitting interim claim. The employer is still being notified that I have a continuous impact, first month 3 days, second month 7 days, fourth month, something like that. Is he obliged to issue his determination?
I think no.
Okay,
No, he no need to give unless the event is finished. He can give once the event is finished.
okay, okay.
So,
So
I
you are
believe that
telling
we have
based on,
to, we have to review it as been submitted. It has to be reviewed and determined interimly. As he's submitting it, it has to be reviewed and determined it. That's my own opinion.
Okay.
According to the FIDIC, it says the engineer should give the determination, interim determination, and if any determination they have given, later the engineer should not deduct that much amount of how much they issued the determination, should not deduct, but they can increase it later.
Okay, okay.
It's not like the progress evaluation, the interim could be used, and as per my understanding, it is a fully detailed claim, and the engineer's determination will be after the event is finished, like the everything is getting concluded. That time the engineer can give the determination. Up to that, there must be a mutual understanding for the interim, like
Okay.
evaluation.
Okay.
FIDIC has no such
Yes.
provision. FIDIC has no such provision for any kind of interim determination.
Okay.
Yes, FIDIC having that having that interim determination, but it's not change the final determination.
Okay. Very good. Very good.
But
Any
client
any
can-
other?
Yeah, but client can ask more information on that.
Yes, you're right. So what kind of information I can ask?
Associate to with that event and anything further, any documentation to understand the proper claim.
Okay. Okay.
Like substantiation, you can say the technical word is, we can request the contractor to further substantiate his claim once he submits the final for a final evaluation or determination.
Now you have identified that the contractor submitted with all the details. There is nothing pending from him.
Then we
He's
have
submitting
to
very perfectly. He's submitting all the document with his interim submission.
so then the
But he
engineer
wa-
has to
but-
evaluate and give determination within 42 days. That's it. Either
But
yes or no.
but the client
Whatever is
should
within
know
48
from the
days.
program
If
point
he
of
needs
view.
further queries, further substantiation, he may request to the contractor. Otherwise, within the prescribed time and as per FIDIC, the engineer has to give determination.
Okay.
But engineer should know the impact as per the program.
Okay. Okay. Thanks for all the concern. I'm raising one question to you all, as you all are expert in FIDIC. I'm raising one question. Go and check that. If you have a FIDIC, check that. Go and check under 3.5. It says that whenever the employer or the contract administrator receive a claim, what they need to do is they need to sit down with the parties to settle amicably. If they don't identify a settlement, then they need to issue determination. Then check it whether it says interim claim or final claim. It did not say, it doesn't speak about whether that claim is interim or final claim. It simply say that if you don't identify amicable settlement, it may be interim settlement or final settlement. You need to issue your determination. So let me tell you one of the interesting story happened to me. While I was working for one of the biggest projects as a contractor, airport projects, we have issued many interim claims to the employee. Then in one of the meetings, we said to them that why don't you give us interim determination, so that will help us whether we need to continue this claim or not. Because when we submit the document, we do submit from our perspective. You might have identified something which is nullifying my claim. So when you give your determination, interim determination, you can give some sort of hint whether should I continue my claim or should I drop my claim. So we asked him to give interim determination. He said no. we are not entitled because 3.5 says that we need to give determinations if we don't amicably settle the thing. Then the dispute went to the mediation level. So we took 8 items to mediation level. Out of that, 1 is whether the employer needs to issue interim determinations or not. The chairperson, she is Dr. Naila Obeidi. She served as a CIARB president. Okay, from Lebanon, she came as a chair for that mediation. I would say that rather than mediation, she made it as an arbitration. Of course, it was such a wonderful experience. So what she decided, what she concluded, she said that the FIDIC is very clear, and it says that whenever you receive claim, it did not specifically say whether it is interim claim or fully detailed final claim. It says that whenever you receive claim, you need to call the parties for amicable settlement. You need to sit down with them. If you don't reach it, then you need to issue determination. So whenever you receive interim claim, you oblige to call them for a meeting, and you need to amicably settle that. If not, you need to issue determination, interim determination. So this is the outcome of the mediation. So FIDIC, unless otherwise you are going to change it, specifically the employer agent, engineer, will issue determination for his final fully detailed claim. Then you need to issue determination for interim. You need to change it if you want. The FIDIC is very clear, saying that whenever you receive claim, it did not tell about final claim. And similar to that, these clauses are telling that you need to submit your claim, fully detailed claim. And if you have a continuous impact, then you need to make it as an interim and submit every month with all the details. So the engineer is obliged to do interim determination. Of course, you may have a different opinion, and this is what I experienced, and this is what I have learned. And of course, I'm convening, I'm transferring this experience to all, and you may have a different opinion. Of course, I respect all the opinions. So this is the outcome. This was the outcome. Okay, she was one of the top-notch person. She knows very well than us, FIDIC. So she decided, concluded this kind of thing. Okay, so in terms of interim, these are the procedures that you need to do. In terms of final claim, of course, it is very straightforward. What it is telling, once you have identified an event which is knocking your time and cost, then you need to issue notice within 28 days from after the start of the event. Within 28 days, you need to issue. That is time bar clause. If you miss that, you will not entitled for any money or any time. Okay, so you need to issue the notice to them. Once you issue that, from the event date, within 42 days, you need to issue the fully detailed claim. All the detail you need to submit. But unfortunately, as we are struggling to collect all the document within 42 days, we simply submit whatever the document that we have, we collect it and identify the program and impact and issue that as an interim, and we collect all the document with an extended period, and next time we submit as a final interim. What FIDIC said, what 28 days notice, then within 42 days strike to the final claim. Once you issue the final claim, the engineer's agent or contract administrator, the employer's agent, he will call you for an amicable settlement. He will call you and sit down with you to completely discuss. If you don't achieve that, then they will issue their determination. I'm not going to go to the dispute resolution procedure or additional dispute resolution procedures, because it's completely different than extension of time. I'm just going to tell you the procedure. So once the employer or the employer agent or the contract administrator issue the determination, that is end of negotiation. That is end of negotiation part. You can't negotiate So most of the situation, the engineers, they don't issue determination, because if you issue determination, then you can't go and discuss with the party again, but you need to go to the arbitration or mediation or litigations, whatever your contract says about dispute resolution procedure, you need to follow to go and get your resolution. So it is very common for the contractors, for the client contract administrators to avoid issuing contract administration. For example, in our contract, we have received 6 claims, and we have identified for 3 claims the contractor is not entitled for anything. So we decided to issue determination, but I advised them that no, we should not. If we issue and still the contractor is thinking that he is incurring cost or is entitled for time and cost, then they will take us to the court or arbitration, which will incur cost to us. Let's try to amicably settle. Okay, so you should not take a decision to determine. You should be patient with it. So in terms of final claim, as I said earlier, it is straightforward. The very first thing is you need to issue notice. Then within 42 days, you need to issue a fully detailed claim. Then from that, within 42 days, the contract administrator will resolve that. If you agree, that's fine. If not, then he will issue his determination. Then if your contract says about dispute adjudication board DAB, then you can go to them, or any other alternative dispute resolution method, you can go to them. Okay, this is the procedures it says. As a client or as a client representative, you have an obligation to act as a fair person. In all situations, you need to act in a fair manner. 1999 very clearly says that you need to act as a fair person. Even though the employer is the one who is paying you and you are working on behalf of them, and FIDIC 99 telling you that you need to do some sort of work as on behalf of client, but at the time of determination or at the time of checking the claim, extension of time, you need to be very fair. In that time, you need to consider many things. You need to consider many things. The very first one, you need to qualify whether the contractor is entitled for time, extension of time under contract or not. You need to check all the clauses, whether it is clearly saying or whether it is giving chance for the contractor to claim his extension of time and claim a cost or not. It should be very fair. The second clause, second thing, that you need to have a reasonable endeavors. You need to take reasonable action. Yeah, if the contractor is submitting, keep submitting interim claim, and you are thinking, and from your opinion, you think that the contractor forget to check one of the document, which is not going to give them a chance to claim additional money, then as a reasonable person, you need to tell them that, dear contractor, you keep submitting this interim claim, but unfortunately, we have given all the document, and if you go and check that document, which is saying that you need to do this work, because the contract document is saying that you need to do the work, you can't claim this work as an additional thing. So you need to be very fair, and you need to do a reasonable endeavors action. And the next one is, regardless of the extension of time will start today or in future, you need to conclude and check whether this extension of time is viable or not. You need to check whether the contractor is entitled for this or not. For an example, you have identified the contractor is submitting extension of time, which is impacting or which will start to impact after 1.5 years. You should not wait and see. You should start your action, and you should identify, regardless whether it is impacting or whether it will impact the program, you need to start to work out or identify the assessment. As well as the assessment should start the point from the point of program updated. Normally every month or every week, it depends on your contract, the contractor submits you updated program. For my projects, every week they're supposed to submit their updated program in order to make sure that they are driving the project towards the program, agreed program. So if you have identified one event as an extension of time, then you need to start to analyze the point, extension of time from that point. You should not wait until some point which is going to give you a favor. You need to start at the assessment point immediately or where the point which is impacting the total program. In overall, if you approved extension of time previously, and now you have identified that because of these changes, the contractor gonna be a serving of time, or the contractor can complete the work early, you can't reduce the extension of time. This is what FIDIC says. You have approved 110 days early. Now you have instructed for an omission. Because of that one, the contractor can serve 10 days. So FIDIC says that even though you are reducing total workload, work days, you can't reduce the previously approved extension of time. Maybe you can change your contract where you can say that we can make plus or minus to the time. Then you can go for it. But FIDIC says that you can't change it. Once you approve, you can't request the contractor to go back. So as a client or client representative, you need to take all these reasonable endeavors, actions in a fair manner to allow the contractor to come and take his entitlement. Okay, that's all under the subjects. Before I finish that, I'm going to give you very small information about one of the free webinar in terms of how to become RICS, MRICS, how to obtain MRICS. We have a free session and by next Tuesday, 21st of June. So if you wish, I think MEQSA will send you the flyer as well as registration platform. You can register to attend this session too. With that all, I'm closing my lecture. Thank you so much for all your patience and thank you for your cooperation. And if you have questions, please, I'll give another, oh, it's 9:24. I'm extremely sorry. I took another 24 minutes. So I'll give another 6 minutes to ask your questions and close up.
Please, I have a question, please. I didn't get you clearly when you said that if you approve a certain of time and you realize that it can be finished less than that time, did you say that you can make a change? You can now issue another less. I don't understand that point very clearly. Can you please come again in that area?
Yes. What FIDIC says that if you read 20.1, the last things FIDIC says that when you are analyzing extension of time, you have identified the contractor can serve 10 days. But in one of your previous extension of time claims analyzed for the same contractor for the same projects, you gave him 20 days extension. Now, this time, this extension of time analyzed, you have identified 10 days minus or saving. What FIDIC says that even though you can serve 10 days, you can't reduce that 10 days from the earliest awarded 20 days extension. Maybe your contract can be different. It can say that if you previously awarded 100 days, and now you have identified 10 days saving, you can reduce the days from your early awarded 100 days. But what FIDIC says, you can't reduce it. In terms of FIDIC, it is telling that you can't reduce that 10 days. But your contracts may be different. Okay?
Okay. All right. Thank you. Thank you.
Yes. Yes.
In concurrency,
Hello?
is
Hello?
Yes.
entitled
Please.
only for year extension of time or extension of time?
What is that? Sorry.
In case of a concurrent delay,
Yeah.
the contract is only entitled for time or time plus cost.
It all depends on the contract. Okay, it all depends on your contract. FIDIC, it doesn't speak about concurrent delay. It doesn't speak about prolongation cost. So concurrent delay, it depends on the method of analysis that you are going to use, or the contract which you are going to use. If you check SCL Protocol 2017, released in February, if you check it, that is giving you an idea how you need to analyze concurrent delay. So there are two kinds of concurrent delay, floats and everything. I don't want to go deep into that. What I can say, one very simple thing. Of course, if you have concurrent delay, the contractor must be awarded with extension of time for an additional time that he was delayed by the client. For an example, client delayed the contractor 100 days. The contractor also delayed the program for 50 days within that same period. Then the contractor should be provided the extra 50 days that the employer delayed him should be provided, but he should prove his cost, that this additional cost incurred only because of employer, not because of his delay. He needs to prove that. Then you can award additional 10 days. It depends on your contract. You need to read your contract, but FIDIC, it doesn't speak about concurrent delay at all. So if you are thinking, if you are a contract commercial person, then you need to include a clause through particular clause to change the FIDIC as you go.
Please, I want to know what you mean by engineer examination. What I know is that when contractor submits their claim, as a consultant, I review it and I make a recommendation to the client.
No, you're not going to give your recommendation.
Can you please define this? What does it actually mean? I want to understand, please.
Okay, so the determination, let me explain you what is determination. Determination is not your recommendation. Determination is your final decision. When you are working for a project as a contract administrator or an engineer, you are a neutral person. When you receive any claims from the contractor, you should not work on behalf of employer. You need to work on behalf of the project. So when you receive a claim, you need to read the claim, and you need to check the contract, and you need to identify whether the contractor is claiming reasonably or not. Then you need to identify all the facts. You need to call both parties to negotiate with them and tell them that the contractor is claiming so and so, but the contract is telling something different, or the contract does not speak about those things, or the employer instruction made the contractor to claim this additional amount. So we two parties need to sit down and agree the time and cost. If the employer is telling that, no, I'm not agreeing with that, I told him at the initial time and so, then these two parties did not come to a common ground. Then as a person, you put all your views and you need to issue your final verdict, your determination, telling that based on my analysis, the contractor is entitled to so and so thing and so amount of money. You should not make your recommendation to employer. You need to identify the fact, and you need to draft your final verdict, and you need to make it as a final conclusion without bias, without taking side for one party. Even though you're being paid by the employer for the project, you are a neutral person. You should take all the things in your neutral view. So it's not going to be a recommendation, it's going to be determination. It is something like final conclusion for that problem. You are giving your final conclusion for that problem. I'll tell you one example. So what happened? We have omitted one work from the contract, and the contractor claimed that they have already executed some sort of work, and they said that they are entitled for the money. The employer then replied to that and say that, no, because you did not submit anything to us. As a contract administrator, as an engineer, I analyzed both situations, and I have identified that we, even before we omit the work through CAI, contract administrator's instruction, or we can say engineer's instruction, before we omit that, we gave them advance copy and asked them to start the work through an email. So as a neutral person, I determined the contractor executed work based on the advance copy provided, and the employer omitted this work way later than that period. Within that period, advance copy and omission, within that period, the contractor did excellent work and many other works, and they have produced many drawings. So for those things, you need to provide certain amount of money, and the amount of money is reasonably this. I should not tell that the employer, the contractor is claiming, so don't give any things. These are the way that you can escape from that. Okay, take it. No, that is something like your bias. The determination means you need to put everything in a neutral way, and you need to find a conclusion based on your study and analysis. You should not speak with someone else who is from a client side and take bias to them. Okay, Femi?
Thank you.
Connection, it was disconnected. Okay, it's fine. Okay, I didn't hear the answer.
Sorry?
Yeah, my connection was having an issue actually. I was asking you, like,
okay,
if you compare the FIDIC contracts starting from 87, 99 up to 2017, and keeping in mind of the golden principles of FIDIC. Okay, as an independent person, if you are evaluating these three contracts, so in terms of the neutrality or fairness, how can you evaluate these three contracts as a purely independent person? Like, yes, the contract.
You are asking, considering the 5 principle of golden principle and compared to 87 and 99, how fair the engineer can act. That's what your question, right?
Yes, yes. To the parties.
So what I can tell that, of course, you are right. 99 is slightly biased to the employer. Yeah, because in the 99, if you go and see, under the engineer's obligation, it says that they need to issue engineer's instruction. They need to review the document that they are going to receive from the contractor on behalf of the employer. They need to do some work. But when it comes under 3.5 determination, guys, please switch off your mics. So when it comes as a determination, not only you're going to act as an engineer, as employer's representative, but also you need to act as a neutral person. It says that very clearly, even though you are going to do some obligation on behalf of employer, when it comes to determination, you need to be a fair person. If you consider golden principle, 5 golden principle, do you remember what is golden principle 3 says? I don't know who asked. Okay, check golden principle 3, what it says. It says very clearly, Yeah, whenever you change any of your contract, you need to follow certain procedures. Golden principle says when you update or doing changes to your contract, you need to follow certain things. Similar to that, the explanation to the FIDIC, which says that FIDIC guide, which says that the engineer, even though he's going to work as an agent to the client, when it comes to the point of determination, he should act as a neutral, fair person. That's what you are agreeing through the contract. Okay.
Hi, good evening, sir. This is Ilarasan.
Hello,
Sir,
yes.
yes, sir. Even though we stipulated the time limit, time frame for notice about the claim to the employer, most of the cases, in some cases, in some contract, the contract usually delayed notified to the employer.
Yes.
So in this case, the employer or engineer can reject only by mentioning that time delay notify. If they are rejecting, yes, sir. If they are rejecting, it will not fall within that unjust enrichment in front of the dispute resolution.
No, it won't. Because, you know, in the common law, I'll tell you, common law, if two parties expressly agreed for any of the terms. For example, I'm telling you that for the construction of this building, I'm charging you 100 riyal. If I agree, and later I identify that I'm not obeying this law, obeying this term, and if I go to the court will simply say that you expressively agreed for this term and you obliged to follow that. Similar to that, the parties, the contractor, he's telling that, of course, I'm accepting your terms and condition. I will submit the notice within 28 days. If I fail to submit that, I'm not entitled to claim anything. I'm with a full confidence, with a full mind, I'm accepting this claim. If your country law something else, for an example, under Sharia law, even though the contractor failed to issue notice within 28 days, even though you reject that, if they go to the court, the law, country law will govern over that. In common law, of course, express term, the thing that you have expressively agreed will overrule. When you go to the court of Sharia law, Sharia principle says that if a person with an agreement did any work, then he should be paid. Regardless whether he failed to comply with something or not, he should be paid. That is Quran and Hadith says, you know, Sharia law. So that will overrule. So in this situation, if you reject their claim, they can raise a concern to the court or arbitration or litigation. Then they can win the case against you. As you said, of course, it is very, very fact that most of the time they don't stick with that time frame, because in the GCC, they know that even though they fail to do that, they can claim the money. It is very common practice. But if you go to the common law country where FIDIC still being practiced, if you go and if you fail, the court will simply say that it is express term and we can't interfere. You two people, within the bound of the law, you have agreed to deliver this and do this. And one party failed and we can't interfere in that. Okay?
Thank you very much.
Hello, good evening, sir. Hello, good evening, sir. This is Rakesh. Can you hear me?
Yes,
Hello?
Rakesh, yes, we can.
Yes, sir. Actually, my question is here regarding the what is the time duration that an engineer fixes for the determination of a claim? Any time duration is there mentioned?
It depends on your contract. What FIDIC says, once you receive your final claim from the contractor, within 42 days, you need to sit down with both parties and you need to issue your determination if these both parties did not agree on any amicable things. But as an engineer, you have an authority to change that. In normal contract, if you take FIDIC and see, every time where they mention 42 days or 28 days or 14 days, they mention next to that or any other time frame or days agreed by engineer between parties. So even though the contract says 42 days, and your contract with this clause, then within the time period of that 42 days, you can have an agreement with these two parties and say that, okay, this amicable discussion will prolong more than 42 days. So let's agree that this 42 days will going to be 60 days or 80 days. We can agree on that. I'll tell you one example what happened. In one of the FIDIC contract which I had, we say that if the parties goes to the mediation, they should settle their mediation within 21 days. We raised the concern to mediation, and we have identified we need more than 40-50 days to finalize that because it was 8 mediation things. So mediators suggest us to have an agreement to extend the period through engineers' instruction. So engineers came to us and agree with both parties, and they set a date even after that. Now go to your contract and check what it says, whether it is 42 days or any other days that party is going to agree. If it is telling only 42 days, of course, within that 42 days, you need to amicably settle, or if you fail to amicably settle, then you need to issue a determination.
If that event is not completed, if that event is not completed fully, then how the engineer can determine the final determination?
He can't issue final determination. He can issue only interim determination.
Okay.
Yeah, he can't issue final determination. He can issue final determination once the event was ceased or once the event end or completed.
Okay. Thank you.
Yeah. Okay, it's almost 9:43. With that question, thank you so much for your coordination, as well as I say that we have another CPD free event. It's related to introductory session, how to become MRICS. It's going to be by 21st, so you all can attend if you wish. And that will give you a lot of benefit as well as information about RICS. Thank you so much. Have a nice day. Enjoy your days. Good night, guys. See you all. Yes, bye.
Thank
you so much. Thank you.
Thank you.
Thank you.
Thank you.